Yeah, start afresh.
Start
Your
afresh.
audio was
Yeah,
not
it's not
audible,
fresh.
and then
You have to
Yeah.
start afresh.
Okay. Yes. Ladies and gentlemen, I was saying that we ended off our evening where we were discussing on identification. We focused a lot on specifically the identification parade. So I wanted to hear, that is, as I've indicated, that is mostly what the state would use if there's issues about the identity of the perpetrators. So do you have any questions on that identity parade? And please, even if I did, I just realized that I didn't touch on the fact that it can be possible that identification can happen without an identity parade. Like, for instance, if the scene of the offense had just happened, then the police are called, and shortly thereafter they managed to make, and the police managed to make an arrest, and the person arrested, can be brought to the witness, and they can be asked if they are able to make any positive identification of them. And sometimes they can immediately right after the incident had just happened. So there is also the identification that happens already when the matter has been ongoing. So the one that becomes challenging, as I'm thinking some of you might know, is what is known as the dog identification. That one is when an accused is pointed out in court and while he is sitting in the dock. So with that kind of identification, there's a great caution that is being applied there, because we can assume that the person that is sitting in the dock is the accused. So any questions on the identity parade? And if there's none, then we close the topic of identification. We can move to the next topic.
let's move forward.
Okay. Thank you, ladies and gentlemen. So we now move to the topic of search and seizure. And here we are talking about evidence that is obtained, and this is done in terms of Chapter 2 of the Criminal Procedure Act. And it often happens that when there's a commission of a crime, there will be items or articles that are going to be discovered by the police, and the same items can be used as evidence to support the case that the police have, or rather the case that the state has. So it happens also that when these items are being produced in court as evidence, the questions surrounding their admissibility will come up, whether the court should allow for such type of evidence to be produced in the first place. And if it is produced, the court will inquire as to the manner in which that evidence was obtained. So there are statutory provisions that guide how such evidence is to be obtained, and safety, the safekeeping of such items, depending on what it is. It may be maybe an unlicensed firearm, or whether it's objects that are seized from the suspects related to maybe a robbery. So there are statutory provisions that would then be guiding the police on how they are supposed to be handling these items that have been seized, and circumstances surrounding that seizure may as I said, they may be challenged, and if there is evidence, they may be found that such evidence was obtained unlawfully. So that would mean that the court will not be accepting that type of evidence, which has been obtained from a commission of an offense. Now, when you are dealing with this issue of seized evidence, and you are the defense that is challenging the manner in which that evidence was obtained, maybe you are saying it was unconstitutionally obtained, the rights of the accused were not observed and they were violated, and proper procedures were not followed in the safekeeping, the chain of custody, whatever that you are challenging regarding these seized items. That issue is not going to be part of the main trial, as we know that when the case would come to court, the charge will, for example, be a robbery. And now when there's items that have been seized and there's issues surrounding the admissibility of these items, whether the court can accept them or not, now this makes the court to now go into what is called a trial within a trial, where specific now evidence will be led to satisfy the court that the court can accept this evidence from the side of the state that nothing wrong happened in how this evidence was obtained and kept safe until it was finally brought before the attention of the court. So when the court is presented with this challenge of such type of evidence, the court has to do what is called a balancing of rights, because the Constitution states the rights of accused persons. And also, please, you can check in your manuals, these sections that I'm referring to, the provisions are already summarized for you also in your manuals, section 19 and chapter 2 of the criminal procedure. Read on them as you, if you want to get full detail about them. But basically, a person would say, my rights to privacy have been violated because I was searched, and I'm of the view that the person who searched me didn't have a right to do so, and maybe they're saying they didn't have a search warrant or whatever that the suspect will be raising as an issue concerning the manner in which they were searched. And they will say they were violated in such a way that their dignity was impaired, and any other, personal or any other rights that they have, for instance, in terms of the Constitution, that they are of the view that they were violated. Now, also in the same breath, the police also have a duty to ensure that we are not just going to observe the rights of persons in terms of their freedom and security. Where there is an issue of a commission of a crime, they are duty bound to do what is called enforcement of the law, to ensure that they will investigate, and in the process of investigating the allegations that are showing that there's elements of criminality that is involved in the conduct of a particular person, they may not have enough time to go and obtain such warrants. They may actually be finding themselves in a pressing situation that they have to act before maybe this person runs away, or maybe they can destroy the evidence. So yes, an accused person can say, I have my rights to bodily integrity or whatever, but the court must do that balancing act to check whether, because these rights, even if they are there for all individuals, they are not absolute. So I've mentioned the provisions of section 36. Yes, the rights contained in section 35, they are there also to give guidance on how these rights in the Bill of Rights are to be observed, but just because we all have these rights cannot prevent, obviously, the police to do what they need to do at times. Each situation will be assessed based on its own merits, and the court will then make take a judgment call whether there was no exceeding, of the bounds of what they were legally expected to do as the police in violating those specific Bill of Rights. Now, Section 20, A to C of the criminal procedure, it requires that the members of the South African police should have what is known as a reasonable suspicion or a belief that there is a commission of a crime that is involved before an article may be seized. And when we are talking about this reasonable suspicion, ladies and gentlemen, I think the words are clear to you for you to see that it is a subjective opinion that an officer will formulate on their own to decide whether, under the circumstances that they are faced with, is there now a good grounds for them to suspect that there's a commission of a crime. So basically, there is no definite the definition of what is a reasonable suspicion. There's lots of cases that obviously have been brought before the courts, even on a daily. This issue of what is a reasonable suspicion, it is debated a lot in the criminal courts, because the court, at the end of the day, has to ensure that even though the police officer is given this discretion to make their own assessment of the circumstances before them and then make a judgment call that I am suspecting that here there's a crime, the court would still have to go into the surrounding circumstances of them arriving at that decision that there is a reasonable suspicion. So it is a term that is used very loosely by members of the police, because anytime they acted, they would, whenever they're asked, why did you approach that person and decide to search them, without a warrant? And this is mostly when there's no search warrant. And they're asked, why did you not, follow the process of obtaining a warrant? Why did you just immediately act on that day without following that procedure? The answer is likely to be there was a reasonable suspicion that the accused was involved in the commission of a crime, and now they will have to be asked, what is it that made you to have that reasonable suspicion? So he must explain that maybe I saw particular actions that were showing that this person is involved in criminal acts, and if I had delayed in acting to execute my mandate with preventing them from further committing the crime, they would have gotten away, or if they didn't get away, it would have been an issue that maybe the evidence could have been disposed of. They could have destroyed the evidence that could be used and then presented before the court to also show that how the offense had been committed. So it's because the term is there, and it happens also that it is being abused at times. And where you personally, from the case that you are dealing with, if you are the defense attorney, you are of the view that the police have, acted in a way of abusing that, reasonable suspicion, and then you will then have to prepare yourself to, address that issue with the police when you are dealing with a trial and discrediting them to show that they just, where, for example, that would be maybe in a case where you are of the view that they were just willy-nilly acting without really having full consideration of their actions on the day. Now, privileged documents may also be seized may not be seized unless the person who has the privilege relinquishes their privilege over those documents. The same under this privileged document goes, for instance, about what we spoke about. I'm not sure whether it was yesterday or on Monday, when we spoke about the confidentiality between you as the defense lawyer and your client. That is the accused and also the defense witnesses, that your discussions are covered by privilege. But if you expose your client, here I'll give you an example. I have seen often that some lawyers, especially at the courts, either maybe because the court has adjourned, or maybe they are waiting for the court to start, they will be at the passages there at the court building, and they may be sitting because there's benches where people normally sit and wait. And if you are discussing issues about the case concerning your client, people may possibly overhear that information. So that action of discussing in front of strangers, or maybe people who are not part of your defense case, you may not know that this is possibly even a state witness who can overhear your conversation. So by you doing that, you are actually relinquishing that privilege, because you are the one who must ensure that your discussions are happening in a private settings, and if you do happen to be in a public place, you make sure that there is no possibility of people overhearing your conversation. So just be aware of that, because I see it a lot when you are at court, that you will see that maybe if maybe they are in court, for example, and they ask that the matter be stood down, maybe they want to address something with their client, they will just walk outside the court and just be around people talking there. So please make sure that people are not hearing what you are discussing, because that can be used against you if you do expose yourself like that.
To interrupt. Sorry,
Yes.
Miss Elsie. I'm
Yes.
not sure if someone is watching TV or what behind you, but we can hear the sound is filtering through.
No, it's not me. I hear the same sound. There's no TV here. No, there's no one here.
Okay,
I'm the only
then
one.
can
in the room.
everybody just mute themselves, because it's
Yes,
very, very
please.
distracting.
Okay, let me just try and see. Yeah, but I'm hearing the same sound as well, but there's no one here with me. So the documents also.
Sorry, also Elsie, can you also speak a bit louder? You are a bit soft today. I can't hear you clearly.
Really?
Yes, you are a
I'm
bit
so
soft.
loud. Guys, you can't hear me? Or maybe it's your device.
Maybe it's my device. Oh.
Yes. Francis.
I also can hear you today.
We can
Yeah,
hear
you're a
you.
bit soft today.
And my
We also can hear you.
No, you can hear clearly. I think it's his device. Let him sort his.
I can hear you clearly.
No, then I think, ladies and gentlemen,
He
if you
keeps
are
on disappearing.
I'm disappearing.
Yes, I lost you there for about 10 minutes.
And
The
guess
lecture.
what?
So that's your connection. We can hear
Yes,
everything
I
from
am
start
not
to
We
finish.
can hear Elsie very well without interruption.
I'm not load shedding, ladies and gentlemen. So sound, whatever technical issues that you have on my side is not because of my network and my device. Whatever that was happening before with the slides, I've sorted it out. So I'm sure whatever problems you have, maybe go out and come back in, then you should be able to hear us. Okay. So, ladies and gentlemen, I was talking about the documents that, like, remember I said when you consult with your clients, you are going to write down those witness statements of the accused, of the defense witnesses. Those are also confidential and also covered by privileged. Now, please ensure that any discussion that you make regarding the case with outsiders, and here I'm referring to, for instance, where after you have obtained your instructions and you have taken a decision to make representations, for example, to the state about the case. Now, you will do that in most instances in writing, where you are making some disclosures to the state. Please ensure that it's going to be in a format of a letter maybe, or it may be an email, whatever that you are writing to the state. Ensure that you indicate somewhere on that letter that that communication is made to the state without prejudice, so that if whatever, maybe you are negotiating some deal with the state and it doesn't work out according to what you were looking for, then it leads to the situation that you have to now proceed into the trial. The state cannot try and, introduce the fact that at some point, in the trial now, if the matter is in the trial, that you had actually, written to them and made some sort of, admissions or things that are linking the accused to the commission of the offense, whereby the deal didn't work out. The only way you can prevent them is if you've ensured that those discussions on that document, you always ensure that you've enclosed those words to say that your communications with them is made without prejudice, so that they cannot come and try and swipe it under the table when now they are trying to prove the guilt of the accused.
Hi, Elsie,
Miss
can I
Elsie, can I
ask
ask a
a
question?
question?
Two people are talking, one at a time, guys.
Okay, it's Shirley. I'm going to go first. Just for
Okay.
clarity, are you saying that while we are negotiating a deal with the prosecution, we can
Yes.
divulge privileged information to them in order to obtain the deal, which then they cannot use if the deal does not go through? I just need clarification on that.
Exactly. Say, for example, you were offering that there's a main charge that the accused is facing, and you say to them, look, I see that you are not going to be able to prove your main charge against the accused. My offer to you is accept maybe a plea on a lesser offense, obviously that will carry a lesser type of punishment or sentence for the accused. And after the reasons that you have stated, obviously when you make that suggestion, you are now showing to the state why you say they will be able to be found guilty on the lesser charge. So because of that, you will implicate the accused by or to the offense and say on that lesser charge, they have actually done something. And then when you make that offer to them, that is what is called a plea bargaining, for example. Now, when you make that offer to them, it is remembered as the state is the dominus litis, it is still their prerogative to decide whether they are accepting your offer or not. And then they come back and they say, no, we are confident that we can prove our main charge of, say, for example, armed robbers. We can prove it. But you are saying to them, for example, no, this person was only found with the stolen items. So please leave that armed robbery and accept only the possession of stolen properties, because my client, he can give you a plea on that. And they say, no, we are confident that we can prove the armed robbery. So you see there, you are incriminating your client on that section, rather the possession of the stolen property, you see. So if that deal doesn't work out, and now they come back and they say, no, we are proceeding with our main charge of robbery because they are looking for a harsher sentence of 15 years. Then when you are in the trial, they cannot, when maybe, for example, the accused is testifying and he is denying, you know, anything concerning this trial, they will now come and say, but say, at some point, your lawyers had written to us saying that you were actually in possession of the items which is linking you. So they can't disclose those discussions in front of the court. That is between you as the state and the defense. Only if you have ensured that you have covered that discussion by including those words. It's unethical in any event for them to try and do that. But you know, there are people who, I don't know, also, I can't say much about the training of the prosecutors, ladies and gentlemen, because I've never gone to a justice college. I don't know exactly how they get trained. Maybe it's also a personal thing that maybe somebody doesn't listen very well. You know, those mistakes of them trying to disclose things that are not supposed to be disclosed to the court, where it was a discussion between the state and the defense. Sometimes they try to put it, they try to put it in to the attention of the court, you see. So for example, I can tell you, I had a colleague this very, I think it was on Monday, she came in with, she's taking over a matter from a private attorney who was dealing with the matter, and the client has taken over, has now requested our services. So immediately when this person just applied for assistance from us, the attorney is given a document that is coming from the DPP's office, and it is discussing some plea bargaining issue there. Now the prosecutor in court, before handing this to my colleague, they handed that document to the court, and my colleague did not know what is written in that document, you see. So the magistrate read through that document, seeing some indications that there was a possible plea of guilt, and now the state is saying, no, we are not accepting it. And then the court, upon seeing this, because when it was 2 copies which was said, one went up to the podium, to the presiding officer, one copy was handed, while the court is in session, handed to my colleague. And then my colleague reading this, she immediately is shocked, and she's addressing the prosecutor, why are you sharing this with the court? Because this is obviously between the state and the defense. It shouldn't be brought to the knowledge of the court. Then, because the presiding officer could see that engagement between the two of them, then the presiding officer said, no, but why did you give me this? I don't even understand, why am I being shown this? You know, I'm not even supposed to be privy to this information. This doesn't concern me. That is what the presiding officer said. So now my colleague now was of the view that, in fact, that matter should be removed from that court. And we all agreed that, yes, that matter should be removed. It must go to another presiding officer who will now, because now already the accused is tainted, do you see? It's been tainted in that the court will obviously not forget that there was some indication that this person at some stage wanted to plead guilty, but only that the state is not accepting on the grounds that they were willing to make that a guilty plea. So things like that, they do happen. So that is why I'm mentioning it to you that these are legal documents, ladies and gentlemen. Please ensure that you will put those words in, and you are vigilant if you are able to stop it, you know, from that being disclosed, like, or you have to take steps like my colleague who then had to ask that the matter be taken out completely from that court, let it go to another court. Okay.
Elsie, I
Yes.
have a question.
Mm.
Is a party allowed to hand over a document to the court before allowing the opponents an opportunity to peruse the document and then allowing for the document to be handed to the court. Is the presiding officer also not negligent in allowing for such a document to be handed to them?
I hear what you are saying, but sometimes if you don't know what is coming to you, you can't block it. You understand? Because it's not a docket that is being handed to them. So they would have thought maybe it's something that concerns them. That is why the presiding officer immediately tried to, to distance themselves and say, but this doesn't concern me. Why is this being even brought to me? You understand? So because he couldn't anticipate as the presiding officer what he was being shown, he thought it's something that is, it's not going to cause problems. Then they allowed it to be given to them. And only now when they see that now there's a whole little squabble happening between the prosecutor and the defense, then then he spoke up and said, no, but why am I giving this? Why did you even give me this? This is not for me. It's not meant for my eyes, and it's not meant for me. You should have gone to your colleague and you should have, discussed it. But unprofessionalism, inexperience, whatever you may say, maybe on the part of the prosecutor, I don't know, ladies and gentlemen. But those kind of things, whether they are mistakes or deliberate or not deliberate, I don't know. They do happen. That is the point.
Elsie, can I ask a question?
Yes.
I just want to know, during search and seizure, what if the accused is disputing the amount that has been seized from wherever premises? How does it happen? Do they IP investigate, or is it the duty of the defense attorney to investigate whether the amount was the amount that the accused is saying it's been seized from them, it's the same amount that has been produced by the IO investigating officer?
Okay, let's make it, I think, simple for everyone here. Use a simple example of drugs, possession of drugs. And they may say the quantity found, the state says the quantity of the drugs is this much on the charge sheet. The accused, from what you are telling us, Nolutando, is admitting to be found with those drugs, but is just disputing the amount. That if they say it was 2 kg, he's saying no, it was 1 kg. Is that what you're saying?
Correct, yes.
But then let's not forget what is the real issue here. It's, yes, the issue of quantity will influence the amount of sentence that will be imposed, right? But the main crime that we should, the elements of the offense are that this person was found in possession of drugs which are illegal. And by them admitting that, yes, I was in possession of drugs, then what are we even trying to do? We can't be putting a matter to trial on a, an issue of 1 kg or 2 kg, because this person is already on their own admitting that they were unlawfully in possession of drugs. So that one, to cure that, it's going to be through plea bargaining now between you as the state and the defense, to say, look, I'm not refusing to plead guilty. Can we, for the sake of progress, find a common ground? Okay, listen, my client is willing. And one thing I can tell you, the state prosecutors, they are not always hard-headed and stubborn that they won't want to see reason. If you are admitting, and the effect is that this person is still going to be found guilty and they will still get, punished. So they may actually say, okay, I will amend the charge sheet and accept the plea based on the accused saying it was actually 1 kg. At the end of the day, the person is still getting found guilty and they are still getting their guilty plea. That is how it normally happens. But if you find, that it's there's no agreement between the state and the defense, then you will now make what we call admissions, not a guilty plea. those are going to be in terms of section 220. And you will admit that on that day you were found in possession of the drug that are mentioned in the charge sheet, but the issue that you deny is the quantity. Now, evidence will have to be to be called, and witnesses will come and testify on the quantity. And then the court will decide at the end of the day whether they believe 1 kg or 2 kg. But at the end of the day, the verdict will still be guilty, because already from their own admission, they are not denying. You see? Okay. So, yes, Tajmi. If you don't speak,
I just want to, I want to check something here. Well, I see that we're dealing with search and seizure, and also about the admissibility of some evidence. I just want to check the issue wherein I'm being recorded while we am discussing crime with somebody. And that is presented to court, because there are instances, like for instance, a person would take a video of you, record you while we are discussing crime. And that gets to be, admitted in court as admissible evidence. I don't know, how does it happen? Because what you are saying here is that matters that are against the Bill of Rights or Chapter 2 of the Constitution, or evidence that has been obtained unlawfully, should not be admissible in court. But it does happen. Or maybe there are certain crimes where in the court, or the court ends up using its own discretion to admit some of the evidence.
See, what I said here, you see, I said challenging this, it's going to be a balancing of rights of everyone, the Constitution and the provisions of the Act in terms of the Criminal Procedure Act. So now the court will have to see this person's privacy being violated by them being secretly filmed, where they were making incriminating statements. You see? Now, before the court can accept that evidence, it will have to do that balancing act to see whether whoever is the one who produces this, were they justified to bring that before the court. If they are allowed to get away, are we, promoting crimes, because the courts are there to ensure that there is people abide by the law. So this applies to both, obviously, the police and to the accused persons. When we say everyone must abide by the law, so the presiding officer is the one who will be the referee now to make a decision whether the ones who obtain, it's like an issue of an entrapment. For instance, where you are trapped, you can also say, if I knew, I wouldn't have, disclosed this information. You trapped me. You made me to act. You led me somehow to act in this way because of the way you made this illicit offer to me that was so attractive that I then fell for the trick that the trap that you set for me. Then the court will then have to decide on that type of evidence. So there's lots of cases as well, for just interest, that you can read up and see how the courts approach such type of evidence as well. But it's a balancing act at the end of the day.
Thanks.
So for instance, with most of these, like your bank robberies, for instance, they would normally produce video footage where now surveillance cameras will show the robbers what happened on that day. Ne? So now an accused person cannot come and say, you cannot produce that video because I wasn't informed that there's cameras that are recording in that place. Because if it's a private property, you know, they have their rights of admission, and they will have disclaimers to say somewhere this building is under surveillance and whatever. So by merely having those words put somewhere, you know, it somehow blankets them to say, by you entering the premises, you are aware that there's surveillance cameras there, and activities that happen there are being recorded. So if they are also of criminal nature, that can be used as evidence as well. Though you are more than welcome, obviously, as a defense lawyer, to also take your own stance on how you will be challenging it. You see? Yeah. So that's for the lawyers, ladies and gentlemen. Okay, so I move to the powers to search. As I've already indicated, that searches happen with a warrant and also sometimes without a warrant. Police officers who act with a warrant, they are going to be covered by the provisions of Section 21 and Section 25 of the Criminal Procedure Act. So as you can see, I'm just saying one line there. That should tell you, in most instances, when there is a search warrant, there's not really that much of a dispute, because the search warrant will detail the reasons why they are there and all that information, and who is the person they are coming to search and what exactly are they looking to find. So there are warrants. I'm not saying they can't be challenged, but I'm saying it's rare that you would have an issue where the police came in with a search warrant. The most problematic one is the one when the police have conducted a search without a search warrant. But they are also authorized to do so as per the provisions of this Section 22. And also please check Section 24, that also gives private individuals some powers also to can conduct a search. So when the police are searching without a warrant, they can do so with the consent of the person concerned, and also they can do it without or obtaining their consent. A warrant is normally obtained, it's obtained from the magistrate or a commissioned officer, and the discretion to determine whether a warrant should be granted, it rests with them when they are going to interview the officer who is applying for a search warrant. They will ask them to state what are the reasonable grounds that makes them to suspect that where they want to go, there is illegal activities, or there is a commission of a crime that is happening there, or that there are illegal items or articles that will be found there. So this warrant, it can be applied for before a judicial officer in their chambers. That is in terms of Section 29 of the National Prosecuting Authority Act, and the directives of the warrant, they must be strictly interpreted to protect individuals against excessive interference by the state. So what are we talking
Sorry,
about?
ma'am.
Yes.
Can you sue the police for entering your premises without your consent and without a warrant, even though they know that or believe that when they go to magistrate court to ask for a warrant, they are going to be given one?
You'll have to, okay, maybe let me hold my answer. Let me proceed here. I'll come to answer you. And I think the case that I'm going to discuss, it will somehow
Sorry.
help us. Yes.
The other gentleman said you are not audible. It is true, you are not clearly audible to us. It's been like for like 30, almost an hour. I thought maybe it would be better, but
Kamugelo, I can hear you perfectly. How come I'm not audible?
yes, I can also hear other people perfectly. Like the lady just that spoke now was very audible. I don't know if there's something that is next to your mic or something.
No, we can hear her perfectly, Kamogelo. Hey?
Is it me alone?
I
Some kind
can
of
I can hear her perfectly.
We can hear perfectly.
Kamogelo, I'm hard of hearing and I can hear perfectly.
Yeah, we can hear perfectly well. I think check that device, you know, even
we can hear her perfectly.
Sorry, guys.
Maybe you need to
Use my
reboot.
device, sorry.
Okay, I think it's well established, Kamugelo, that the problem is your device. Okay, so I'm sorry, please, maybe go out, come back in.
Sorry, guys, I'm still with Kabukelo on this one. Elsie, you are a bit soft. I don't know. I honestly, when other people are speaking, they are loud and clear. You are soft. We can hear you, but you are very soft. Other people, when they come
If
in,
she's
they are
soft,
nice and
please
loud.
try use earphones.
It might be
Earphones or change the audio
it might
from
be your
Teams
devices.
audio to device audio.
Is it
You
on
can also
loudspeaker?
Guys, you can also select the audio that you want to use. If you don't want to use the Teams audio, you can use your device
I have a
because we can hear.
suggestion. I have a
What have
suggestion. Maybe
experienced
instead of
before?
us having a leg stretch 7:30, can we have a leg stretch now for 5 minutes so everyone who's having a problem to reset their system for 5 minutes? Then we don't have another further leg stretch.
That's exactly what I was about to suggest, that let us all, for those who have challenges, I'll also log out and then come back. Let's give it 10 minutes. It's almost past. So 22, then we will resume. So hopefully everyone will be able to hear.
And no more leg stretch.
Elsie?
22.
Elsie?
22.
Elsie and everyone in the house. I just wanted to say, when you come back, it happened to me before, and I was told that when you join into the MST meeting, don't mute your mic immediately. Just join and then mute your mic immediately when you are in, because somehow it interrupts with the speaker. So it happened with me before, not on this platform, but I was told when you join into the meeting, there is that opportunity to mute your mic. Don't mute it before you join. Join and then later you mute it. And then that's how I've never experienced a problem like you are experiencing now.
Thank you
So
for
just
that.
try it.
Thank you. I think everyone has heard you. Yeah, so you come back with your mic on and immediately when we get on, we'll mute. Thank you. 22, ladies and gentlemen.
Minutes. 20.
We can hear your background. Can you please mute your mic, please?
Nathaniel, dog is barking.
My apologies.
Mute yourself. Make sure that you are muted. The dog will bark. You won't stop it from barking.
Nah, I will do. My apologies. I just was waiting for the lecture to start.
Yeah, we understand.
Can somebody help me? I cannot see the slides here.
The slide is up and it's on page 17 of 26. So maybe again,
Yeah,
try
but my
refreshing your
screen.
page.
Yeah, but my screen is always blank, so I do not see any slides.
Did you not
download
block
them?
incoming video on your side?
Sorry, ma.
Did
you
not
download
block
them?
incoming video? If you cannot see them on
I
Teams, maybe
cannot
try.
see.
Yeah, maybe try downloading them on the website, because maybe you blocked it on your settings on Teams. So you can maybe try downloading the slides that are on e-leader. When we're on day 2, slide 17.
Oh, okay. Now try it.
I think alternatively we can just reboot your device, and that might solve the problem.
Ladies and gentlemen, I'm back. Can you hear me now?
Yes, we can.
Yes. Okay. So for those who cannot see the slides on here, we are on 17 of 26. So I think we just have to move accordingly, because really we can't be going on and off and off. And yeah, I think people have mentioned, I see in the comments about network problems. So that is understandable. But the session is being recorded. So Zukiswa can confirm as well that I think they will make these recordings available for someone who maybe is of the view that they missed something, then they can have access to the recordings. So, where were we? We were talking about the warrants. Yeah, we were here where we were saying even some, okay, I'm happy to hear that sound is much better. So it means going out has worked and coming back in. So private individuals can also, under section 24, check the circumstances under which they may be having authority to conduct a search. Now, I ended up saying that the decision to grant this search warrant is going to be based on the information that the judicial officer is being given to explain this reasonable suspicion that the police are saying they are having, or their suspicion that should they be able to access the premises or be able to enter a particular place, certain individuals, as mentioned in the warrant, will be found in that place. They will be able to make a successful arrest, and they may make some seizures of illegal items that are connected to the commission of the crime. So the question often comes when, okay, this search warrant, like I said, it will be interpreted strictly, and it will give specific directives. For instance, the name of the police official who is allowed to execute the warrant will be mentioned there. They may have backup, but it will have a specific name for the officer. The purpose of the search, the specific articles or items that they intend to seize, the address or for the premises that are to be searched, whether any person found on or at such premises may also be searched. That will be stated in the search warrant. So the case of the Minister of Safety and Security versus Van der Merwe, further gives us more guidelines for how the police are supposed to effect those search warrants or execute those search warrants. Please check also the matter of Polonifis versus the Minister of Police, and see also there also more clarity on the situation where there is a search warrant. There are cases that I have met where the police came to a particular place and they found individuals who, that line where it says any other person that is found in that premises, and they were actually subjected to searches. So you can also see how the court approaches that one. If that was not included in the search warrant. So say, for example, the search warrant was specific to say, we are going to look for LCCB at this place. And when they get there, they find that there's 5 other people with me. Now the question becomes, are they also allowed to search those 5 other people if the search warrant did not say any other person found there? Now it becomes an issue of what was the reason for the police to actually end up needing to search those people. They will have to explain if they were also partaking in the criminal activities that were happening there, and if they were justified to have searched them, even though they were not specifically included. As I have said, with a warrant, it's a specific directive. And if the police are to do anything outside of what they is stated in the warrant, then it will become a problem. So it doesn't mean that if they find, you know, that they were looking for 2 suspects, but they actually find 5 suspects and there's a shootout between the police and the 5 suspects, they can't accost them and search them and seize their firearms and take them into custody, because there the police will explain that, yes, we went there to search 2 people, but we were actually in an exchange of, you know, there was a fight that ensued, and in the fight, then we ended up having to protect ourselves as the police. We overpowered them, then we eventually searched them, and we found them with illegal, you know, firearms. So I hope you see how it doesn't necessarily mean that if these words, any other person found, is not included on the search warrant, that the police cannot touch. Please let that be clear. I hope that makes it clear for everyone to understand.
Elsie, a question.
Yes.
The specific articles to be seized, I think it's related to your question, your answers now. But if a specific house is to be searched and
yes,
and there's items listed for illegal firearms, and let's say Dacha is also in the house, but it wasn't listed, may they also seize the Dacha?
No, but I think your example of Dacha will be problematic, because remember, the possession of Dacha it's not it's what it has been declared that it's not you know, there's this issue of what is the purpose that you are using the Dacha for. What is the word, guys?
Yes.
Help me. You know that if you are smoking it for intoxicating purposes, then it becomes like you are sharing it with others and you are getting yourself high. Then I think that's where it's a problem. But if it's found in the premises and it's being used for medicinal purposes, then it's not a crime. So maybe
Okay,
you
but
should.
let's say it exceeds the, let's say they grow it for a saline in an excessive amount, just for the sake of argument.
But even
Or let
for
us say Menrex.
even that's what I'm saying. Let's not use drugs, because even what you say is excessive amounts that are planted there, it can be used for medicinal purposes. Because if somebody says 10 times a day, I'm drinking this dacha for cancer purposes to alleviate my pain, then it means they are consuming a lot of dacha. So then that doesn't necessarily. So
Let us rather say mandrake.
Yeah, that is why I'm saying please don't use dacha, because it's tricky with dacha. So if you say it's another specified, clearly specified illegal drug like mandrakes or heroin or cocaine, then obviously we know that the law is clear. If someone is found in possession of those drugs, the police cannot just leave it lying or just turn a blind eye to that. They will have to dig deeper on that, investigate about the presence of that, and if they can link it to someone, even though, like I said, they came there for a specific reason, like you stated, but they find something extra, they cannot turn a blind eye. Because these are illegal drugs. Yes.
Hello, can I ask the question?
Yes.
When you apply for a search warrant to search place at night, when does night start and when does it end?
Yeah, I think there's a discussion on that. I saw it, I think, in your guide there, ladies and gentlemen. But I know there's an issue about time. Please do me the favor and read it on your own, that one. Please, this is definitely something you will not be asked in your assignments, your board exams, or whatever. It's just for information purposes. So please, I don't want to lie. I'm not sure. But I saw that there's an issue about time when you want to execute this warrant. Okay, please.
Thank you.
Okay.
Okay. Can I ask something?
Yeah.
What if the people are not at the designated premises, but the police see them on next door maybe? Could they still extend the search warrant?
Then it says here, the address of the premises that is to be searched must be stated. So if they go next door, they might have a problem there.
Even if they see those people?
It depends. Like you see, it says the purpose of the search. If the purpose of the search will be fulfilled by them going to next door, they will rely on that. And the specific item that they are looking to seize, they will rely on that. But someone can challenge them that this warrant is not just there for nothing. You must comply with exactly what is contained there. In any deviation, obviously you need to have good reasons why you deviated. So if it's just an issue of an address, but all the other things like the names of the people you were looking for, they are actually correct. The purpose of the search, you actually find what you said you are looking for, and all those other things, I think they can try and push it in.
Thank you.
Yeah.
Hi, may I ask a question?
Okay.
Yeah, you spoke
Oh,
of
there. Sorry. I see the warrant must be executed by day, unless if it is specifically stated otherwise. That's to answer that question about time. I knew that somewhere there's an issue. It must be executed by day, but it can be directing that it must be done at night. Okay.
Sorry, LC.
Yes.
You can apply to search the premises at night. But the question is, when does night end? Because day starts after 12. So is it, do you look at the time, or do you look at the light of day?
Oh, come on, that's a question.
Yo, that's a tricky question, guys. Assembly. But then it needs more. There's someone says, let's check page 50 of the guide. Maybe it will help us on that one. Eh? And then maybe there's more information given about the exact times as you are asking. But I can just say that the warrant issued can be executed on any day. It can be a public holiday, it can be a Sunday, it can be any day. But the issue of specific time, I'm just not sure. Generally, it must be executed during the day. So we will suppose that during the day is from sunrise to sunset, I think, in common, language that we use. And anything after sunset can be considered night, but I'm not saying I'm right. You please, if you can get the specific there to say, yes, else you were right, then I'll be happy also to know. But
it
it
makes
does,
sense.
but you see here, it is allowed that they can specifically, they can direct that it happen when it is not a daytime.
Yeah, but it makes sense what you're saying. From sunrise to sunset is during the day.
Yeah.
And then it. But I'm just my question is just on if the times that the warrant is executed, if it has to be stated in the affidavit when you apply for the warrant.
I lost you there.
If when you submit an affidavit for a search warrant,
yeah,
must the search to be conducted be in that affidavit and in that search warrant? Because if you search outside the hours of that search warrant, it becomes unlawful.
Yes, that is why it says a warrant must be executed by day. So where it's done outside daytime, then it must be specifically mentioned in the warrant that you can do it outside of daytime. And I'm sure it would be, yeah, it's an exception, that one. I think.
Ma'am, can I come in,
When does
ma'am?
a search warrant
Yes.
expire? When does a search warrant expire?
Because it
Ma'am,
states the day, it states on the warrant when the date, the time when you are going, it will be stated specifically there. So if this is supposed to be today and you go tomorrow, then already it's expired.
Okay.
Yeah.
Ma'am, just clarity, can I come in?
Yes.
Yes, ma'am. I think just for progress sake, how a search warrant is applied is the police officer or the investigating officer will approach the prosecutor with the said information. We want to search house number 4. This is what we are having. These are the allegations that we're having.
Yeah.
The prosecutor is the one who approaches the presiding officer to say, if we search during the day, we surely cannot get anything.
Yes.
Then we are requesting that we search around 8 to 12. It will specify. So with the said warrant, it will give you the date, the time. You'll surely approach the said house. You will search. There won't be any problem because you've specified the reasons why you want to deviate from the searching during the day. Yes.
Yeah. Makes sense.
Thank you,
Thank you
ma'am.
so much. Thank you, Mr. Kos. So I think we can put that issue to rest, guys. Let us not hold ourselves to, we do the same thing about peace officers again. We are clear here. So only.
I have a question.
Okay.
What's the point?
I have a question, please. I have a question regarding privileged document and the search warrant. Whose responsibility it is to identify privileged document when executing a warrant?
You, who has the document, you are the one who will refuse to submit that document to the police and say, no, police, you can't take this document. If they have taken it, because sometimes they will take it, then you as the attorney, when you come on board, you will then approach the state and say, state, when you executed your warrant, you happen to seize privileged documents, and you will say which are those. I think you've seen the case that played out in the media. Okay, someone says page 48, but you've seen a case where I think it was the former President Zuma, his lawyer came and challenged after the police had done their work to search and seize, and then he came and said part of what you seized was, privileged information that you shouldn't have. So you will raise that, and then you will debate it between yourself, and then if found that you are actually correct, that that information is privileged. Yes.
Can I do something before we move? Which one is important as far as the search warrant is concerned? The address number or the ERF number? This matter, it reminds me of a success from SAPS, where the warrant was issued and a number of drugs were found on the premises. But on technicality, the premises, it was in the corner. They found the drugs on the number that was specified on the search warrant, but on different ERF. So I think it was a combined structure, but different ERF. But that case was kicked out because of that.
It's an issue for argument. Like I say, guys, if nobody would have raised that issue of an ERF and a house number, you know, because that's where you would get those differences, then everyone would have focused on the fact that what was found was actually an illegal substance.
I'll see just one question, one remark here.
Yes.
The search warrant, if it's obtained for a person that's wanted for a certain crime, there is no time period for the search warrant to expire.
You are saying that there's no time period mentioned for a wanted person?
If a search warrant is obtained for a person that's wanted, for example, murder, there is no time period for that, for the expiration of that search warrant.
But no, I'm getting confused there, because the search warrant will have to say, like our colleague who helped us here, to say that it will state the time, the date, and all that. So unless if you are saying the case will remain pending on the hands of the police, that there is this outstanding person that is still wanted.
The case is open, but there's an outstanding a warrant has been applied, and the warrant will only expire once a person has been arrested. So there's no time period. If you look in, I think.
Can I just interject, please?
Yes, Lloyd, help us, please.
We're talking specifically about the search warrant.
Yes, so that sounds like a warrant to arrest somebody, what he's talking about.
Warrant of arrest, yes.
Yes.
Okay, ma'am, can I come in again? Can I come in again,
people
ma'am?
are confusing between the search warrant and
a wanted persons.
Yes.
A
So here we are
J50
talking about the
warrant.
search warrant. Yes.
Yes, ma'am, just to come in, I believe the gentleman, when he talks about the warrant which has no expiry date, he's referring to the J50 warrant, wherein you are looking for an accused, you can't find the accused, you apply for not a bench warrant, but a J50 warrant.
Yes.
That warrant lasts forever. The person is circulated throughout the country. You can arrest the person after 10 years, it doesn't expire. So we are not talking about the J50 warrant, we are talking about the search warrant.
Search warrant, yes.
Yes, ma'am.
Okay. Thank you, colleagues. It's clear. I think our colleague understands. Okay, so now a few things about how that search warrant is to be executed is to say that when the police are conducting this search, I put question marks here. It says no private persons or forensic auditors may take part in the search. And remember what I said about section 24? That is dealing with search warrants for private individuals. Please, that is why I'm putting it there, that don't forget, read that section and see how they can be put involved when this search is getting executed. Now, experts can be maybe your forensic experts, as an example. They may be present, but it says that they may not participate. So what they will do, the police will do the searching. And when they have taken whatever they've taken, maybe then they will just come in and do what is called sweeping the scene to pick up maybe with fingerprints and samples that can be taken for testing. But they are not going to be doing the searching. Now, regard to decency and order is to be observed during this search. That is to say, a woman should be searched by another woman, a male should be searched by another male. Section 22 now deals with search without a warrant. Now, it empowers them to do this under the following instances. If the person... Yes.
Sorry, yeah, maybe
when it
before
comes to
move to the search
without a
without
warrant,
I just want to check.
Mm.
Yeah, no. This one, the last point you are raising,
About
the one
decency.
about a woman being searched by a woman. I just want to check something there. Earlier in your presentation, I think it was day before yesterday, you indicated that among others we deal with the rights of the LGBTIQA persons. Now, how do we deal with a situation where biologically this person is a woman, but then they identify as a man? So how do we deal with that so as to ensure that the principle of decency and order is not infringed for people who
But that
identify
question is
differently?
unfair.
That is not part of board exams, guys. These are the questions that delay us. I just think there, in simple terms, it depends on how the person identifies themselves and who they would be saying they feel comfortable being searched by. I think that is how maybe the police would handle it. So here we are just avoiding a situation where a woman would say, I feel violated because I was handled, by males. So in that situation, maybe that person that you are referring to would then make their election on who they would feel comfortable to search them. Okay. Now, the police here now are going to act without a warrant, and they have to now search a person consent. Under this section 22, it says instances that if the person consent is now giving consent, is agreeing to being searched. Police, if on reasonable grounds, they believe that if, like I gave you that example, that if they don't act timeously, they risk the possibility of the person running away or maybe destroying the evidence that they would have managed to find on them. So they have this reasonable suspicion, and on this reasonable grounds, they will be warranted to act and do a search without a warrant. So the reasons that they would give would be mainly, if asked, why didn't you get a warrant? They will state that the delay of obtaining this warrant would have defeated the object of the search. A peace officer who then arrests a suspect may search a person arrested and seize any article that is referred to in terms of section 20, which is in possession or under control of the arrested person. Now, there are also situations where the police would have to enter premises, not just to search, but they would have to enter premises where they do not have a warrant. They can do so to obtain evidence, and they can also enter those premises by using force. The only time that they are allowed to do this is when their aim to enter those premises would not be to just conduct what is called questioning. And where they are going to apply force to enter the premises, this is what is discussed under Section 27. We have what is known as the no-knock principle, where it includes the fact that they can break a door, they can break a window, forcefully enter. Then that Section 27 says a police official may use such force as it may be reasonably necessary to overcome the resistance against such a search or entry. Now, if articles for which the police are searching, they may be destroyed or disposed of. I'm saying in brackets there. These items can maybe be swallowed or flushed away in terms of drugs or maybe illicit diamonds. The police, they need not audibly demand entry before they pounce on the suspects. They are allowed to enter unannounced. So, ladies and gentlemen, the case of State versus Gumede, it was decided in the Supreme Court of Appeal. I don't think it's that old. It still stands as a very good example for you to consult when you want to see how police conducted a search without a warrant. They obtained evidence, as well as there was a pointing out at the scene of the crime that happened in that case of Gumede, which was made after the arrest was made. Now, the police, in this case of Gumede, they claimed that the matter was urgent for them to effect a search and enter the premises, because they said they had no time to obtain a search warrant before the assailants could escape. So basically, in that case, the police briefly went into a home of a suspect who was led to them by a informant. There was a few months prior to them going to the home of Gumede, there was an armed robbery that happened in a pension pay bond. And there was a shootout, money was taken of the pensioners, and one of the security personnel at the pension pay point was injured. Actually, he was shot, I think, on a leg, but they didn't die. So there was an armed robbery, there was charges of attempted murder, there was possession of unlicensed firearms and live ammunition that Gumede and friends were facing. So what happened is that the police relied on the information of this informant, who then said Gumede and friends were involved in that past robbery. They went into the home of Gumede on the information that Gumede and friends were intending to leave the area. They were intending to escape. So that is why the police then found it urgent that they did not need to waste any further time. And they came in the middle of the night, around midnight, and they broke down the door. They didn't announce themselves when they got there. They kicked down the doors, and inside the house, they found Gumede. He was sleeping, but under his pillow, there was apparently a firearm that was then found to be unlicensed, and somehow it was related to the shooting of that police, I mean, a security officer who had been shot at the scene of the crime. And then Gumede was taken into the police station for questioning, and at the police station now, shortly after midnight, confession came out of Gumede. So when the state went to trial, they were relying on also not just search that was done and where they found these items, but after the confession was made that according to the state, he had admitted that he was one of the robbers. The pointing happened in that the police said Gumede took them to the scene of the robbery, and some pointing out were made to say, I was standing there, this one was standing there, and whatever, during the scene of the crime. And from the pension pay point, the police were led to the father of Gumede, who stayed some distance away from the scene of the crime. And the police were saying they were led there by Gumede because he was saying he was going to show them where the money was hidden. And they got to the home of the father of Gumede, but for some reason, the money was not found. But still, they were happy because they got all that information and they went back to the police station. By 6 a.m. the following day, all this what I'm telling you about was done. So please keep in mind that the police arrived at the home of Gumede shortly after midnight, but by 6 a.m. all that I'm telling you had been done during that time. So when the matter went for the trial, Gumede was found guilty and convicted of all the counts that they were facing, but then he appealed that conviction and sentence, and now he was raising an issue that the confession was obtained by him being assaulted. It was not voluntarily obtained. And now the court had to hold a trial within a trial because the state had relied on that confession also as part of their case. And that was one of the main issues that they relied upon to secure their conviction. So when the matter went on to appeal until it reached the SCA, ladies and gentlemen, I'm summarizing briefly. Please read it on your own if you want all the details. The court at the SCA was particularly concerned about when did they get the information that Gumede was involved in that robbery. And it transpired that the information was actually given to the police some 2 days or 3 days or so, 2 or 3 days before they actually went to the home. Let's agree on 2 days. 2 days before they got the information that Gumede was involved, and then they went in on the 3rd day to now break down the doors and arrest him. The court was of the view eventually there that that 2 days was sufficient time for them to have obtained a search warrant. And another issue that was sitting uncomfortably with the court there was the fact that the amount of time, 2 main issues. The fact that the police had 2 days to obtain, the court could not be satisfied why they couldn't use that 2 days to get a search warrant, 1. And number 2 main reason in that SCA case, the court was concerned about the time between that midnight when they got to Gumede's house and the whole of all these confessions, pointing out one place to another, going to that place. Also, there was a difference of interpreters. There was an interpreter who was called in when they were taking down the confession, because the officer who initially was interviewing him, I believe, did not speak Zulu. So they eventually between midnight and 6 a.m., they managed to secure someone who spoke the correct language that could be understood by Gumede. So everything, the time frame to wrap up the investigation of that entire robbery that had been lying without being concluded since it had happened was done within those few hours. So the time that the court said it was so short for them to have wrapped up that that case within that few hours when they had been sitting for months before they got a lead to Gumede. And that in the mind of the court, that time between midnight and by the morning after, the court was somehow pressed to accept that maybe Gumede was not lying when he says he was actually beaten up. And guess what, ladies and gentlemen? That matter, the court set aside that conviction and the entire sentence. So Gumede walked away a free man. Even the firearm was found to be unlicensed. It was tested, ballistics was produced. It was, even the court there said the whole evidence was unconstitutionally obtained because the rights were not complied with. Now, you go, you find another case that you can find that can actually, you know, but put aside this matter of the case of Gumede, but as it stands on the issue of searches, arrests, and seizure, the highest court that has decided on the issue still remains this one on the matter of Gumede. So if you can find something else, because fully speaking, there's developments every day, and we will be very happy to hear if there's something else that is existing out there. But there you just see how the court approaches the issue of search without a warrant, entry without announcing themselves, the no-knock principle, and the seizure of that firearm that was unlicensed. And even though it was proven to have been a real firearm, the court still did not convict. I mean, accept that conviction of the Kotako. The whole conviction and sentence was set aside because of the constitutionality of the actions of the police on that day. Whether you agree or not, that's, yeah, I have my opinion on it, but it is what it is. Okay. I'm moving on, ladies and gentlemen. So, where a police official conducts an illegal search and seizure, such evidence cannot be admissible if presented before the court, and a police official who acts contrary to the authority of a warrant I'm sorry, is liable on a conviction to a fine or imprisonment for a period not exceeding 6 months. Those are the sanctions that are provided for in terms of Section 28 of the Criminal Procedure Act. And a person who gives false information under oath, under Section 21(1). Now here we are talking about that officer who gave an affidavit when they were obtaining a search warrant. And based on the information that they have given, it turns out that the information was false. That person can be convicted of perjury. The court can also authorize that an award of compensation in terms of Section 300 of the CPA be made to the person who was prejudiced by the police who acted out of such wrongful information. So there was an earlier question about people who say, can you sue the, there was an earlier question about someone who said, can you sue the police where they acted without a warrant and whatever. So in criminal law, the criminal procedure gives a compensation for someone who is complaining or is found to have been searched or their premises searched and things done in an unlawful manner. This one is a provision of the Criminal Procedure Act, but this does not prevent you to pursue a civil claim against the police for such. But this is what is stated as per the criminal procedure. Okay, now, those items that the police have, they have seized, and it happens that because of their what they are, those items, they may need to be disposed. So Section 30 to Section 36 of the Criminal Procedure deals specifically with the procedure that the police will follow to dispose of such items, and also there are times when these items will be forfeited to the state. These seized items or articles will normally be kept in police custody, and if required to be presented as evidence in court, they are going to be brought to the clerk of the court or the registrar of the High Court for safe custody. Now, if the object has been handed in court as an exhibit, the presiding officer must make an order as to how, now when the matter is being wrapped up, what must happen to this item. The court must give direction whether this item must be forfeited to the state or whether this item must be disposed. And if it must be disposed, then we will check that Section 30 to 36 as to how it must be disposed of. There are times when seized articles are not going to be forfeited to the state or disposed. They will not be destroyed, let me rather say. They will not be destroyed, but they are going to be returned if it can be established that they actually belong to a particular person. And then the court will direct that, say for here, we are talking mostly about like your simple one would be a cell phone that was robbed. And if the complainant is in court, then the court will then direct that as the case is being wrapped up, they've proven that the cell phone actually belongs to that complainant, that now they can be handed back their cell phone. Now, a seized article can be returned, I said, to the owner if needs be, and it will be done in court so that it's in open view, so that there's no issues of I didn't get it, and it will be there in court that they will be called and say, ma'am, state, hand it over, then the state will hand it over. Confirm, ma'am, that this is yours. Yes, you know it. Yes, I confirm. Then the handover has been completed. If no person may lawfully possess it, or the police do not know the person who may lawfully possess that item, then this article is going to be forfeited to the state. And Section 35(1) empowers the court, after if it has convicted an accused, to forfeit certain objects that were used in the commission of sorry, a particular crime. Money. So the different laws are applicable when it deals with the forfeiture of certain items. Like if you are dealing with liquor, this was the painful one that happened for instance, during those lockdowns, remember, ladies and gentlemen, the sale of liquor, transportation and whatever of liquor was not allowed. So that's where we saw the police minister taking those whiskey bottles, and I'm not sure whether that is I don't know. Maybe if somebody wants to say anything, they can say, but like the way it was, the bottle was held up so high, like, yeah, you see, and then it was like 2 bottles and the alcohol was just flowing down, and yeah. So I don't know if that was also meant to send some other type of message, I don't know. And if that is actually the procedure that the police normally follow, that they have to hold bottles so high and record themselves when they are actually, but I don't know, like I'm taking it that maybe there was a message. So with drugs, also, we check the Drug and the Trafficking Act, counterfeit goods. We often hear also how they are found, and that also they will be destroyed. So, ladies and gentlemen, that is all on these search seizures and all of that. Yeah. Do we have questions? I want to introduce a new topic. I'm changing my slides so long.
Ma'am, I would like to ask a question in terms of Section 300.
Yes.
Would Gumera have succeeded if he had sued the state because the outcome was in his favor in court?
Yeah, when you sue in civil procedure, remember what I said, that you will have to also prove that civil case, that the police, one, you have to show that either they were negligent in the manner of handling of that case, and even involve the prosecutors to further pursue that case, to say that they were not also just negligent, maybe they were also malicious. So those are the 2 key things that you would be looking at proving in that civil case. So do you think the police were negligent? And was there any malice? Did they have anything particularly against Gumede? Or they were actually thinking that they were justified? Yeah, maybe they were thinking that they were justified as they were asked, why did you not act on that day that you received the information to obtain a warrant? And they gave reasons or in court. And according to them, the day that they went there was the closest they could actually go there. And they thought, because of this information that we have, that these people are about to run away, we still have a good reason to go there without a warrant, just because we've been given the information that they're about to run away. So I don't know. It will be a case that you would argue and you would fight it out.
Hi.
Yes.
Hi, sorry. I just wanted to ask, man, in the case like that you were speaking of Kumet, what happened to this illegal firearm? Is it forfeited to the state?
Yeah.
And second question is that I wanted to ask, in terms of, like, let's say the police were searching and then they found a stolen car. How long do they have a right to keep it as evidence? Like, when does it get returned to the owner? Can they keep it for years while they're investigating? Yes.
That's a tricky one. If it is still part of the investigations, maybe that will be the reason why they say they're holding on to it. Because I've seen cases that come in court, and before the case is actually finalized, they do hand over back the item. So even when it actually comes to trial, then the witness will come and testify, and they will be asked, where is the item? And they say, no, it was handed back to me. There are those instances, but there are those that will be kept in a yard, packed. Then there, the police would have to justify why they didn't give it back to the owner. Maybe it's linked to commissions of other offenses. I don't know. Maybe that could be the reason. But once the case is wrapped up, if there's no good reason for them to continue, I know that then the court would now make a pronouncement of what should happen to the item. So if it's an illegal firearm, they are normally going to be destroyed. If the real owner is known, then it will be handed over back to the real owner.
Elsie, can I come in here?
Yes.
What? There's a case I read just recently about a man who was arrested and his firearms confiscated, a hunting rifle. The case was thrown out of court. The judge ordered that the 2 guns be returned to the owner. And this was 3 years ago. He's still trying to access the guns. The police have lost the guns.
Oh, yeah.
Is that common? It seems like it is common.
Yeah, I've heard of that happening a lot, that the guns, not just only the guns, I mean, things get misplaced where there's a place, what, I forget the name, it's where they book in all the exhibits. So they have to have like a register to keep a record. And there are cases that actually come to court where the court would have wanted to see the item. And when it's called for that item to be brought to court, then they will make statements to come and say the item has been lost from that booking center. So I'm not saying they are right. I don't really know what happens inside SAPS, but I've seen those instances and heard of them as well. Unfortunately. Okay. So we move, ladies and gentlemen. Thank you. Now, is this person going to sue the state for the loss of their firearm? I'm just curious because you guys like suing, yo. You sue the state for almost everything.
Can I come again, ma'am? Come in,
Yes,
please.
yes, Mr. Koza.
Yes. I think the register you're talking about is the SAP 13 register.
Yeah.
And there is only one police official in every police station who is the custodian of the said register and the said items that are kept at the station. So I once had a case similar to that one. Without suing, you can actually open a criminal case of theft
Against
directed or specifically to the custodian of that SAP register. Yes. So there can be a criminal case open for theft of whatever rifle or whatever item that was actually kept there, because they're expected to keep it till the matter is finalized.
Now, I've also heard of instances where that book will reflect that actually one other officer, maybe the investigating officer, had actually come and booked out those items. But I mean, they do that. I don't know for what purpose, maybe, I don't know. And then somehow the trail, it becomes unclear after it was taken out. And it can't eventually, even if you can see who was the officer who took it out, when you try to follow out again from that one again, it becomes difficult to say eventually where did it end up. So yes, I hear you with you wanting to charge this duty officer, the safekeeper, but it can actually not actually be his fault at times.
May I ask a question?
Because if say you are the investigating officer, that officer, I don't think is gonna refuse when you come and say, I need to take this item for whatever testing. They're gonna allow them because they sign to say on this day at this time, I've signed out the item. Okay.
May I ask a question?
Yes.
I wanted to ask about the register. What if it differs from what the police say and what the client says, that the police say X, Y, and Z were on the register, but the client says there's more which has not been accounted for?
Like, for instance, where money was recovered. Say this
Yes.
heist, this money heists, you know?
Yes.
The actual victim where money was collected would say, the security officers who came into my shop, they collected 10 million. And then at that date, only 10,000 is booked in.
Yes.
Colleagues, help us there. I don't know. What do you say?
How guys help us?
I
Mr. Khoza.
think it will be, the onus will then be obviously on the complainant to prove. Let's say, for example, they say had 10 million. For example, if I can give an example, we have a business wherein Fidelity comes and collects the cash. So fortunately, when they collect the cash, there's a receipt, a printout of how much they actually collected. And it so happened that they were actually robbed. In one instance, obviously, they did not collect money from one place. They collect money from several places.
Yeah.
So it's then up to you to provide the proof of how much money was there. But for example, if now it's the police coming into your house and you are saying you've got 5 million stashed in your couch, one, that's illegal. So it's then up to you to say, are you
Actually,
willing
that's a
to...
bad example. Please don't use the couch.
Are you then willing to say, to confirm and incriminate yourself to say you had that much money in the house, which again is an illegality on its own?
Yes.
So it's a matter of, it's a very touchy thing. And a couple of years ago, I personally had a robbery with an ex of mine. They were suspecting him of some criminal activity. We had a party, the police came. They did take cash and a whole lot of stuff that we had in the house. By the time the case was thrown out and we went to 13 to collect our things, you will not believe that all we got back was a 6-pack of Hunter Dry. And they claimed everything else was lost.
You were even lucky to get it.
That's all we got back. And they claimed that everything else was lost. And we just let it go because pursuing that matter was just going to cost us more money anyway. So it's, yeah.
Okay, thank you.
Thank you, guys.
Hello.
Yes.
I think with the subject of the money, they can also use the forensic photographer, and also it's a duty of the police to record the serial numbers of the money that is seized. At somewhere, also use the forensic photographer to take photos of the stacks of money that has been found on the scene or that is seized. So that will actually be some kind of evidence if it goes to court and there is a dispute of the amount of money that was seized.
Yes. But the recovery, as we are all saying, it's a challenge that is going to be left for the owner now. You know?
Yeah, in most cases, whatever goes to 13 never comes back in full, you know, even the cars. If your car was kept there, it's likely that you get it full, you know, with all the tires.
Yeah.
Can we take the 10 minutes break then and come back with a new topic, please?
Yeah, guys, I think we've established that there's a problem that we can't solve. Hopefully one day SAPS will get to the root of it. Okay, new topic, ladies and gentlemen, is now jumping to what is known as the methods of securing the attendance of the accused in court. Now, this can be done as we've been talking about it since the first day, that it's normally through an arrest. And when the police have placed this person under arrest, they can also place them in custody by keeping them in their holding cells. Now, because of the invasive nature of an arrest, that is normally not encouraged. It should be done as a last resort by the police. Because when you take a person and you place them under arrest, you are definitely going to now have an issue of limiting their freedoms and and. So arrest should be authorized by a warrant, but we know that it also happens without a warrant under these circumstances that we've been discussing. If the police see an activity that is happening, they were unprepared. Obviously, they didn't walk around with a warrant to arrest. So they will then be justified to effect an immediate arrest. You can check the section 39 of the criminal procedure if you like reading regarding how those two types of arrest would be happening. Arrest can also happen in terms of, I bring this in because in the, I'm not even gonna say in the big cities, I think it's now a national issue because foreign nationals are everywhere now within the country. So it's not just, but it's still majorly obviously in the cities, but they are also in the smaller towns and villages as well. So arrest can also happen in terms of the provisions of the Immigration Act. Now, this arrest that I'm talking about is where is an arrest in terms of Section 34(1) of the Immigration Act, which says that a court can issue a warrant of detention and also or authorize a deportation of illegal immigrants. This case that is cited here of the Lawyers for Human Rights versus the Minister of Home Affairs has ruled on that Section 34, particularly subsection B and D, and it was eventually found that those two subsections were found to be inconsistent with the Constitution. Here is the issue now regarding foreign nationals. The Immigration Act says if you are in South Africa and you are a foreign national, you are the one who must prove that you are legally in the country. Now, when the police, okay, I don't know. You can see the slides, guys. Yes?
Yes.
Thank you.
Yes, we can.
But everybody has the slides. Yeah, everybody has the slide. Yeah. So now it may be the police, it may be the immigration officers themselves. When they meet up with a foreign national, they ask about their status in the country. Then it is the duty of the foreign national to prove that they are legally in the country by producing evidence to that effect, which will be permits, visa, whatever that would then be legalizing their stay within the country. So in this case, it became contentious because a lot of illegal immigrants were being kept in detention centers for prolonged periods of time. I'm not particularly clued up exactly now what is happening because I haven't really dealt with that issue. But I know if up to 2020, you know, the issue of even overcrowding was a huge concern at the deportation centers because illegal immigrants were just kept in detention for those prolonged periods of time, which ran to be years in certain cases, without them being finally sent back to their countries of origin. So when this case came out, the Lawyers for Human Rights were particularly fighting the Department of Home Affairs about that long detentions that was happening at the deportation centers. And because certain provisions of that Section 34(1) B and D were said to be inconsistent with the Constitution. Somebody decided to think that the whole Section 34 has been found to be inconsistent with the Constitution, which now in practice meant that all the people who were illegal immigrants and they were actually kept in detention had to immediately be released. So it was a whole issue in the courts because they had to even get an opinion from the state law advisors to come and give clear guidance on how the courts are supposed to interpret the situation now that there was this case. There were magistrates who didn't even want, even when they just, they had a standard form. Immediately they said this is an illegal immigrant, they will just sign it and boom, stamp it and say release. But the essence of what was said there is this, ladies and gentlemen. Where a person is illegally in the country, the first thing is that, yes, they may be put under arrest and they have to appear in court like a normal accused person, right? Where they will, but they have assigned courts in bigger jurisdictions, because obviously the situation will also not be exactly like that if it's a more smaller towns or your rural. The same criminal court that deals with everything will deal with also with immigration issues. But it is happening in the criminal courts, but they will assign a specific courtroom and a specific presiding officer who will now preside over the hearings of these detained persons. They will appear there, they will be advised of their rights for like just like an ordinary accused person. They will be, they can elect, to have legal representation if they want it. And yes, now the court will go into the legality of their status in the country. If at the end they are found to be actually illegally in the country, the court will now make an order that they are going to be further detained, not at the police station, but at a detention center. Now, the court will also specify that within a specified period, their deportation must be processed so that they're not going to be staying in those detention centers for too long. And if this, the immigration services are having challenges with getting the deportation done within that, say, 30 days that the court is giving them to finish off the deportation process. If it's either the time is expired or they foresee that they are going to be needing more time, they have to bring the matter back to court to come and explain that we are not going to be able to deport at this time that the court has given us to deport. And these are the challenges that we are facing to effect the deportation. We are now seeking a postponement of the process of deportation and asking for extension of time. It cannot be perpetual, ladies and gentlemen. They can do that maybe once, maybe twice in exceptional circumstances, but eventually the idea with this case is that this deportation must be done and it must be finalized, and people can not just be roasting at the detention centers because it's a violation of human rights. That is what I wanted to share with you. So if you get into those kind of cases, just be aware and make sure that they are bringing them back timeously and ensuring that they are not just being kept there without following the guidance that has been laid out now in this case, because the position has been clarified. So I say that the effects I've discussed, the court will then hold that inquiry and further detention can be granted, extension can be granted. Oh, and sorry, this includes bail applications where it is found that, you know, they're having to prolong this. The applicant, I mean, the illegal immigrant can ask to be considered for a bail. So the idea is that detention should be procedurally and substantially fair. Therefore, an order of court is necessary. So I've discussed with you guys, and the rights of the accused of a criminal case will be applied in the same manner. I've informed you there. So yeah. Okay, the second method to secure the attendance of a, do we have questions or what? I'm hearing someone talking. So I'm moving to the second method of securing the attendance. It's summons. Now, summons are often used if the accused is not in custody, or obviously they will not be arrested. These summons will be served by police officials. More is talked about on how that service is going to happen under Section 329 of the Criminal Procedure Act. They are normally served these summons in person by handing over a copy at their place of residence. It can also happen at their place of work or business to a person who is over the age of 16 years. And these summons are supposed to be served 16 days prior to the date of hearing or trial. And a return of service will be prepared by the person who effected the service, who handed that summons. They will report back to the court to say who was handed that summons, and that return of service will constitute a prima facie proof that service was properly effected. Next method of securing attendance is what is called a written notice to appear. Section 56 of the Criminal Procedure Act talks about this notice. It's prepared by a peace officer. It's commonly served on children and the parent of that child or the guardian, where they are to be appearing before a preliminary inquiry after it is alleged that the child is involved in a commission of a criminal offense. Now, release on warning can happen for these children or child offenders. Under Section 72 of the Criminal Procedure Act, the police themselves, they can, or the court can release a child offender under the care of a guardian. And this release is going to be subject to the condition that the person who is a guardian of that child is going to be warned that they need to ensure that they bring the child to court on a specific date that will be given to them. So the idea here is because of, you know, children they're fragile. So we try to keep them out of the prisons and all that system. So best to make the guardian to be responsible to make sure that they are brought to court. Okay.
Sorry.
Yes.
Didn't last time you said that a written notice to appear can also be issued by like traffic courts?
Yes, like for maybe a specific, if it's not gross, a specific traffic offense, they can give you that notice to say, go and appear at court on this day. They can do that. Then you will go and see the prosecutor at court, and then they will lead you whether the matter is going to be appearing in court and all that. Okay, somebody says they're struggling with concentration after 2 hours. Suggestion is that we take 5 minutes, or yeah, 5 minutes. We're almost at the end. Let's stretch. I also need a bathroom. So it's 8:05. We can resume again. Is that okay? Thank you. Yeah. Ladies and gentlemen, we are back. Before I move to the next slide, I remember that from that program that I was given, there was a mention about charge sheets. So charge sheet is what is going to be presented by the state once they have taken a decision to place the matter on the roll. And we are still on slide number 22. So the charge sheet is commonly referred to a J7. It's called a J7 form. And on the face of the charge sheet, it's just going to give the details of the station, where the case has been reported, the investigating officers, the police case number, and and the one that will be allocated at court by the prosecutor now. It will have, because the one at the police station, it's called a CAS number. And now once the matter is it's enrolled in the court books, it's now going to be given a case number. And then from there, on the front page of this charge sheet, the most important thing there would be the names of the person that are accused. There may be more than one, so there can be more than one page of that charge sheet concluded with the full names of the accused and their addresses. And I often see that the police, when they write on the name of the accused, they also include alias names that the accused are also known as, because I don't know whether it's a good thing or it's not a good thing. There are people who have street names, and actually their street names and are what they are better known with than their actual, names that are in their identity documents or passports. So sometimes when I say this may be a good thing, it can also be a bad thing, because that's where you get those names of a gunman, and yeah. So if you are getting that kind of a charge sheet, I just want to quickly ask on that aspect. How would you react to seeing, just for argument's sake, Sibusiso Lawrence Dlamini, or let's say Sibusiso, in brackets, gunman Lawrence Dlamini on the charge sheet? Would you be okay with it just because it helps to identify the client, or would you have an issue with that gunman being included there?
Elsie?
Yes, I'm listening.
Yeah, I think it will create a prejudice when someone sees that kind of name, simply because, the association to that particular person. So I think it could be to the detriment of the accused. Just my personal view.
Yeah.
Hi, Elsie. Can I
Yes.
just say something? I also think it's actually affront to the person's dignity, because he might, that's not his name. Okay, his name is on the ID book, but he's been branded that name by the people that know him. So it's an affront on his dignity and his rights to his proper name. I'd object to it completely because it's also branding him as a certain person, not sweet man, but gunman. And that indicates something dangerous and criminal.
Yeah, but also there's people who take pride in their names. While I'm talking, yes, I am not saying you are wrong. I'm thinking about situation where I saw a video of a well-known convict who was going by the name Maleven. So he would identify himself as such. Whoever met him, he would say, my name is it Maleven or Maseven, guys? He was everywhere. Is it Maleven?
Maleven.
Yes, it's Maleven.
Yeah,
it's Maleven.
So is it Ulira? They take pride in their names. So is it the police to be blamed for you referring to that name? Because maybe that is how, even when you ask the police, they would tell you, when I first asked the name, that is the first name they told me. Then I said, no, give me your real name. Then they went into the other names.
Okay, got it. Yeah, I agree there.
Yes, I was about to assist there because it's assisted to clearly identify the suspect.
Yes, that is what the police would say, that even to make sure that we arrested the right person, we had to make sure that we arrested Slicer. You know what is Slicer? The one who is known for evading the law. Because he's always on the run. You know, but yeah, they take pride in the names, and I'm not saying it's right. I fully agree with you, Iluira, because to me it would look like, you know, the magistrate, the presiding officer would look at that name and they would question what kind of a name is this if they're not clued up about. But to a common person who's familiar, and most of our, presiding officers, they are familiar with these three things that are happening. So immediately you get that, then it's, to me, it's prejudicial. It's painting a picture already, But yeah, so you'd have to decide whether you are going to allow it or, yeah, okay. Yeah, Slicer, it's another one. Yes.
Just for interest sake, it's not only that the name that is being reflected in the identity documents, but some of our clients walk around with other names, and then when the police takes the fingerprints and the 769 reports come out, then you realize that on that other alias name, there's also crimes committed on that name. Thank you.
I've seen that. Yes, because the police are also keeping their own profile. Every time this person brushes with the law, they give a different name to the police, and they can bring that whole record to show that on this offense at this particular place, under this different type of offense, this is what was the name given to us. And that is when you are dealing with a bail application, that they will bring that information to show that this person is someone who is evasive, because they can't be relied upon, because they use many different names. You are right. So, and then what else is on the charge sheet, face of the charge sheet? There is a part down there that would leave some room for the court to, the presiding officer to make some inputs, whether this person is going to be, the part for sentence, it's also on that face of the charge sheet. But when we're talking about the charge sheet here, the one that I think mostly is what you were supposed to focus on, as per what is on the slides, is the next page of that charge sheet, which is called the annexure. That's where now the charge that this person is accused of is going to be stated there. So it will say the place where the offense is alleged to have taken place, the date, the area, the name, if it is known, of who was attacked, for example, and how they were attacked, or the weapon may even be mentioned sometimes to say stabbed multiple times with a knife or shot with a gun, or whatever items that were involved with basically the elements of the offense. If it was a theft, they would say how the theft happened, from whom the items were taken, what was taken, and if it's a robbery, it would say the manner in which, in brief. It's very brief. So the main thing that I think we should focus on when it comes to the charge sheet is that the state, they are supposed to complete that annexure in full. I've seen in courts where you will find only that front page with the name, station, IO, phone number, whatever, case numbers. That part is always completed. But in some courts, you may find that annexure is there, but it's a standard form that they have, and it's not going to be filled at that earliest opportunity of first appearance. Now, you must insist that if you find a charge sheet that is incomplete, you must insist that it must be completed. Inform the court that the accused needs to know, he has a right to know what are the charges, because at that stage you don't have the docket. So that is the only thing that can give you an indication of the charges. So I know that there are times when the prosecutor would say, we are still formulating the charges. We are still deciding if we want to add more charges. If, yes, I understand that. But I think the charge sheet cannot be bare, just being a pro forma form that is not fully completed. It must at least, even if all your charges are not fully stated out in terms of the multiple counts that they may have, but at least the main counts should be reflecting on the charge sheet, and then you can know, even on the issues of bail, whether this is an offense that would require for you to be just granted bail or whether your bail will be opposed. So that is why it is important that charge sheet must be completed. And also on the charge sheet, be careful that sometimes when they put multiple charges or counts, that's what they are called, then there mustn't be what is called as a splitting or even a duplication of the charges. So you will have to now, that's when, obviously, when you have the docket copies now, you've fully consulted, and then you can see whether the state, because they would want, at that initial state, they tend to want to put as much as they possibly can put on top of the accused to show that they are having a serious case. But now, once they have done their investigations, some things are not able to be fully completed. Then you will see that some annexures now are going to be pulled away because now they have insufficient evidence. So they will now start to withdraw some of those counts. Even at the stage where you've been informed that the investigations are complete, you've been given that full charge sheet, you've been given the contents of the docket, you go and you prepare. Come the day of the trial, before now they proceed, they will just call the case and read, and you have prepared for 5 counts. Then you will see them reading into the record only 3 counts or 2. And you'll be like, okay, what happened? Sometimes the court will ask, because if they were aware from the first appearance that their counts were multiple, and they will say, no, they've taken a stance not to proceed with those other charges. So basically what I'm saying is, before the accused pleads, they do have an opportunity to amend the charge sheet. You can oppose it if you see that it is prejudicing your client. But in most instances, if they are withdrawing further counts, then I think it works in favor of the accused, because then you don't have to answer to those things. Then you won't object when they are removing those things, those other additional counts. Last thing on the charge sheets, when you do proceed to trial, it's now established that, okay, we are proceeding with robbery. You've prepared on that, you continue, you go on. Now, when the witnesses testify, the element of force is one of the elements of the offense of robbery. And it is not something that they're able to prove that, yes, items were taken, but it was not in a forceful manner. There is what now the court would have to, remember the charge that is put is for the accused to be charged with robbery. Now the court has been presented with evidence which is not completing that element of the offense of robbery. The state, instead of saying we can't prove robbery, they would stand and say to the court, yes, we were unable to prove robbery, but we're submitting that we were able to prove what is called a competent verdict, which is a lesser offense. Say maybe they were able to prove all the elements of theft. Then they would want the court to convict not on robbery, but rather convict on theft, because they were able, through their witnesses and evidence, to prove a full case of theft. So it doesn't necessarily mean that if you were charged with one offense, if they are not able to fully prove all those elements, that you cannot be found of what is called an alternative to that charge. Sometimes this doesn't even happen at the instance of the prosecutors. The court itself, when it's assessing the arguments and the evidence presented before it, it can come back, the presiding officer can come back himself or herself and come back and say, from what has been presented before me, I am not able to find guilt on robbery. Instead, I'm finding guilt on an alternative, which is the offense of. So the person is still being found guilty, but now not for what they had originally pleaded on when the charge was put to them. I hope that is clear. Nothing else really that you should really stress about concerning charge.
Elsie, can I ask a question?
Yes.
Does the vice versa also apply in the matter where, say, the accused is charged for murder and the court sees that no, maybe it should be premeditated murder and ups the order to like a higher count? Is that possible? Because in your example, it basically goes from
up to down
to theft.
Yeah, but
The way around.
And I haven't, honestly, in my opinion, in my experience, I haven't seen that happening. The only thing that I have seen is that the severity of the sentence. The court, when it's passing sentence, would even mention that, in fact, you were I'm talking based on my experience. I'm not sure if it happens. If somebody knows, they can tell us. But what I've seen is that the courts would normally say, in fact, you were lucky that you were not actually charged for the most serious offense. The state actually could have even proved, that offense, but for whatever reason, they decided to opt for, this one that they have successfully proven. So when the court is now a passing sentence, they would now, be a little harsher in their sentence, because they are of the view that you were actually lucky not to have been charged with that one. But it is obviously the decision, like we said, dominus litis, they decide what to put as a charge. And if they didn't put that one that they could have actually proved, to be something more serious, then the court would work with what was put before them. And then it would be an issue of a sentence where the court will say, you actually, what you did was more severe than what you actually charged with. Okay.
Clarity seeking, Elsie.
Yeah.
In terms of that alternatives, so can the court order for an alternatives sentence, or conviction that was not presented by the state. Like maybe the state was supposed to put on their charge sheet that the main count is murder, alternative is culpable homicide. So if they haven't put on the charge sheet the alternative, can the court also charge the person with an alternative that was not presented by the state?
Yes, they can. That is why I said sometimes when the state sees that they on their own were not able to prove their case, they can suggest it that the court would convict on a competent or alternative. And the court itself can also come and say, I am finding that I can't find guilt on the main charge. So I would rather, because of the evidence proven before me, convict on alternative. So also just to go back to, I think it was Dion who asked about the higher charge that was supposed to be put, but it actually like murder instead of premeditated. I know, for instance, when it's an issue of appeal, then the matter goes, say for instance, this person, the court was of the view that they should have been charged with premeditated murder, and they were actually convicted on murder, which is less. Now they get that lesser sentence and they decide, no, I'm actually, oh, thank you, Renir. Thank you for that. Yeah, it was Renir who asked that question. Now they actually decide that they're not going to even accept that lesser sentence. They want to appeal the whole conviction and sentence. They take the matter to appeal. Now, two things can happen when they take it high up to the higher courts for appeal. Obviously, the conviction can be confirmed and the sentence remains the same, or that they can actually confirm the conviction and increase or decrease the sentence. That's what I know would happen. But I've never actually seen where the whole charge is changed. No, the judges would just impose a even more tougher sentence than the lighter one, which in their view was given by the initial court, the court accord. So they would say, no, that court that gave you for 5 years was actually lenient. You should actually have gotten 10 years. And that's what the person would get, which would be more in line with the premeditated, for example, which is the more serious offense.
Okay, thank you.
Yes, Prince. Let's hear Prince.
Yes, well, I'm not sure if I do understand you, because my understanding is that the alternative should have been pleaded by the other party. So in the absence of that, will the court be in a position to come up with new grounds which had never been pleaded by the other party?
They will say, this is the words that the court will say that you will not like to hear. This court is not just meant to be here as a spectator. The court must apply its mind to the case and the facts as they are presented before it, and examine the evidence presented. And the main thing for the court to do at the end of the day is to ensure that the interests of justice, when they pull that line, you must know, Aubrey, you are finished. The interest of justice. Because they will say, because there is a sleeping prosecutor in court who didn't argue for an alternative, I cannot turn a blind eye. My duty is to ensure that the interest of justice, that is what they will say. And you are finished.
Sorry, Elsie.
Okay.
Can I come in?
Yes.
Can the examples that you used earlier, can that be equated with the Oscar Pistorius case, where he was initially found guilty of culpable homicide by Judge Masipe, and that was actually appealed by the prosecution and subsequently changed by the higher court?
Yes.
Yes, that would be the same.
I was about to suggest that.
The state actually was of the view that it was very technical, that case. But yes, I agree with you. I don't want to say something wrong, but I see where you are going. But yeah, that's the state was not happy with Masipa's judgment. So it was now the state who was disagreeing with the court, because again, in most instances, it's normally the accused who are making the appeal. So it was actually the state who were unhappy there, and they took it on. Okay.
Can I come in as well?
Yeah.
Okay. Just on the issue of the competent verdict, usually, like we are saying that the courts, or rather the presiding officer, will not rely on the sleeping prosecutor. The
That's what
prosecutor
they will
has the
say.
right to put alternative counts, but before you even plead, the presiding officer is compelled to inform you of competent verdicts, to say it's murder, it can be attempted murder, culpable homicide, assault, GBH. So presiding officers will be telling you all these competent verdicts before you actually plead. That allows them that should the state fail to prove murder, then they can go down to lesser charges.
Yes, that would have been done. And that happens at the stage where they are reading the charge now, they want the accused to plead. So that's where that warning will be thrown in.
Correct, ma'am.
Yeah.
I just want to check a competent verdict as well as the alternative. How you explain it? It sounds as though it is the same. Am I correct? Because when I'm reading here, it says that a competent verdict is the one that does not appear expressly on the charge sheet.
Like the example I gave, where now the court it will come and say the only charge that was here was a robbery, and there was no additional, because normally they would put those additional annex charges. The prosecutors would put additional annex charges, which are the alternatives, should they not prove the main count. That's what it means, what you are reading.
Elsie?
Yes, but what
Can I
I'm
check
trying to
something?
establish here is that a competent, I mean, the alternative and a competent verdict, are they the same?
No.
No.
They are not the same. So what they would do, depending on their case, if they are already shaky that, you know, this main count that we have, we might not fully prove it, they would put it as the main charge, and then they would put, sometimes it may be 2 or 3, which are said to be alternatives in case they can't prove that which they want to prove in the main count. And then if the court now finds that, okay, they can't prove the main count, then the court would look into the already attached alternatives that are there. And then the court will find guilt on those, or one of, or whatever is the alternative. Now, the competent verdict, it's what I'm trying to, for me, I've let me say, it's when the court was presented with a main charge, but the court is of the view that this person shouldn't have been charged with this entirely. And then the state can plead on either themselves on a competent verdict to say, please don't let this go, this person just go scot-free. Though we didn't charge them on this, we were able to prove this, or the court will then come itself and say, I'm finding on a competent verdict. But I didn't prepare clearly on how to present this to you, ladies and gentlemen.
If it's not murder, it's culpable homicide.
Yes. So, okay, here we are saying the elements of the offense are that, say, for what he's saying, it's murder, it requires intention, but the person has died either way, but they are not able to prove the intention, but the person has died at the hands of the accused. So they would find that the manner in which that death happened was in a negligent manner at the hands of the accused. Then they will say, okay, this is more competent. Then they would give that. Thanks for that example. I think it's more helpful. Or in the case of driving negligent or driving recklessly. That's where now it concerns the similar action of driving, but the driving would be, the main charge in that case would be reckless driving. But then if they can't say that they were reckless, then they would say competent verdict would be negligent driving, which is the less serious one.
LC.
Okay.
Yes.
Well,
LC.
I just
Competent
wanted to
verdict.
check.
Competent verdict is when, like we have said, like murder. Murder, the force is used, or maybe the force is used. And then if it is going down now to assault also the force is used. Where there is force, you see, then those are the crimes that are competent vetting, where they have got they've got same elements. Some of the elements there is the same. Then those are competent vetting.
Like another one I'm thinking of now, attempted murder. Now they see that, no, this person did not actually almost intend to kill, but the assault was still there. They will now decide whether it's assault with intent to have caused grievous bodily harm, instead of them being found guilty of attempted murder.
That's correct.
Yes.
Yes.
Ma'am?
For a charge to stand, must it not have all the elements of the crime?
Yes. And if it is defective, you can say, because you cannot answer to a defective charge. You will oppose that charge and say, this charge is defective. I cannot plead to this, because you'll say, what is the problem with it?
Okay. Ma'am, can I come in for the last time?
No problem. I think we are closing with this. We're gonna talk the next topic on tomorrow. We'll start a new topic tomorrow, so it's fine. We can finish off with this.
Come after Brilliant, if you don't mind.
And then we close, guys.
All right, thank you.
Ma'am?
Yes, Koza.
Okay. Yes, I wanted to clarify that my colleagues should not confuse it. The competent verdict and the alternative count, they both mean the lower charges from the upper charge or from the prime charge. But the difference is that the alternative count is preferred together by the state when they are putting the actual charge. The competent verdict, it's the one that comes from the magistrate or the presiding officer. When he sees that the main one is not proved, then he's moving down to the lower ones. Then competent verdict is for the magistrate. Alternative counts are preferred with the main murder count, culpable homicide, assault, GBH, whatever you put them down.
Thank you, Mr. Kos.
Thanks, man.
No.
Elsie, as we close, I'm not in full agreement with Mr. Kosa, and I'll tell you why.
Okay.
The competent verdict, it should be supported by the material facts. So initially, then you'll have the alternative verdict, and as you peruse the material effect, that's when the competent verdict will prevail. Not to say that the competent then is something that emerged out of having.
No, it's not new. It's not a new. It's flowing from the main charge, but it's only that there was something that they couldn't prove on the main charge.
Elsie, the term used is concurrent charges in terms of the main charge. That is the term that is used in most cases.
Yeah, you want to create more confusion.
But competent verdict comes from the presiding officer.
I think the competent charge come in when, for instance, you cannot prove the main charge, then the lesser charge to the main charge then kicks in. That's what is called competent charge.
Okay, I'll start with this topic tomorrow again to give more clarity.
Yeah. Okay,
More detailed and specific, because I don't want you guys to go and wreck your brains again about this. I'll just go in again on this issue because to me, I think the purpose is just for you to know that there is a case where you would be charged with a main charge, but the state, if they cannot prove all the elements of that main charge, it doesn't mean you get scot-free. And then that's where the issue of alternatives and what, and then I'll try tomorrow. I will come in with maybe what would be the examples that will be more helpful. That's what I will do. So I think we are in agreement. Yes, ladies and gentlemen. So I'll come with something tomorrow before we start with the new topic. And thank you very much for. We are on slide 22. Yes, ma'am. Of 41. Thank you and have a good night.
Thank you. Thank you very much, Mr.
Okay.
Good
night.
Thank
you. Thank you. All right.
Bye.
Bye. Bye. I don't know, Zukiswa, are you stopping the recording?
Thank you, Elsie. Bye, everyone.
May I have Zugiswa's email, please?
Class and